The long-awaited Brinker decision by the California Supreme Court is bringing clarity to employers across the state.
For years, employers have been puzzled by what does it mean to provide a meal break.
It defined when and what obligations there really are for employers in giving meal periods and rest breaks to their employees.
In the past decade, there have been countless individual lawsuits and class actions over meal and rest period violations, giving employers little direction.
The California Supreme Court finally clarified what does it mean to provide a meal break. Does it mean that the employer has to ensure that the employee does not work during the meal break, or does it simply mean they have to make that time available to employees?
The Brinker case started as a group of 5 Chili's employees who didn't like going to lunch early, then having to work another 5 to 10 hours after without another break. It turned into a class action of nearly 63,000 employees, leaving a big question mark where meal and rest period rules once were. Brinker Restaurant Group versus Superior Court of San Diego changed all that.
One of the challenges in the case was, do you have to provide the first rest period before the first meal period? And the court said no, there's no requirement in California that the first meal period be after the first rest period.
The rule in California is that they're now entitled to take a 10-minute rest break as soon as they work more than 3.5 hours in a shift. And for every 4-hour period that they work, they're entitled to one 10-minute rest break. Probably the biggest takeaway or benefit to employers from the California Supreme Court decision is that employers are not going to be monetarily liable in these court cases if employees choose on their own not to take their meal breaks.
The court held that the obligation to provide a meal period is satisfied when the employee is relieved of all duty for at least 30 minutes and allowed to leave the premises. Employers don't need to worry about any longer whether they need to babysit their employees, so long as they provide the required meal and rest break time.
Before the Brinker decision, rules were more ambiguous. There was a wave of class actions against employers seeking unpaid overtime wages at time and a half. There were also premium penalties for the missed meal breaks.
It's a practical matter that it provides great new flexibility and freedom for both employers and employees. Before this decision, if someone wanted to work through lunch and leave a half an hour early because they wanted to take their kid to a soccer game, they arguably couldn't, because if the employer had the obligation to ensure or mandate that the break was taken, then they wouldn't be allowed to work through lunch. Otherwise, they would be owed a premium hour wage of pay.
The decision, however, does not provide absolute protection. Employers must be diligent with carrying out the new rules defined.
The Supreme Court made very clear that probably the most important thing for employers is to have a really well-written policy that describes the rights of employees to take meal periods and rest breaks, and clearly explains to them that they're authorized and permitted to take those types of breaks.
Employers now have even more options.
One possible step that employers are taking is to program their electronic timekeeping system so that employees can't clock in any earlier than taking the full 30-minute meal period.
Breakers are becoming an effective way to make sure the rules are followed.
Some employers, especially in maybe the manufacturing facility or in the restaurant facility, could implement a process where they have one particular employee identified as a breaker for that shift, and that employee moves from machine to machine or from station to station if it's a restaurant, breaking each of the other employees while they take their half-an-hour meal period.
The Brinker decision is unique to California. Companies doing business in California need to pay careful attention to the state's employee-friendly labor laws. The Brinker decision now can direct everyone to exactly where to look.